get settled. We'll be starting in just 7 minutes.
Good morning, everybody. Welcome. I guess it's just 1 minute left in the morning till we get to the afternoon. Good to see everybody here. I see the room filling up virtually. We can see the numbers going up. And I can see lots of chat going on in the group or in the chat for the event. Looks like, if I've got this right, the person who's joining us from the furthest away is Montreal. If anyone's got Montreal beat, for furthest person attending, let us know. Happy to see some Vancouver Island people on there, Vaughan, Alberta. Yeah, let us know in the chat where you're joining us from. And not that there's any prize for the person who is joining us from the furthest away, but it's just going to be an interesting note. So we'll get ready. We'll get ready to go in a couple of minutes. We're just letting people join. And in a moment, we'll have our introduction in as well. Oh, we got someone from Surrey, BC, nice local to our office. Maybe for the next one, you can come attend in person.
Hello, everyone. So it's noon now, so we will get started. It's great to see people from all over joining us. My name's Taryn. I'm here to make sure everything runs smoothly. I'm going to be moderating the chat. So if you have any questions at all, please leave them in the chat. We'll be going over them all at the end. If we run out of time, excuse me, we'll send out a follow-up email with all the questions that we answered and those that we didn't as well. And if you have to leave early for any reason or aren't able to attend the entirety of the presentation, don't worry, we'll be sending out the slides as well as a recording sometime next week. And with that, I'll pass it over to Owen to get started.
Perfect. Thanks, Taryn. People are still filtering in, but we will get going. And looking forward to any questions that we're going to have at the end of all of this. And so a quick introduction for those of you who don't know me. My name's Owen Logan. So it's Owen spelled E-O-I-N, pronounced same as O-W-E-N. We just like to spell everything in Ireland with as many vowels as possible. So, and as you can probably tell from the tie or my green jumper today, I am from Ireland originally. So I graduated in Ireland from my law degree in 2008, and then I did a master's in law finishing in 2009. My immigration journey, I came to Canada in 2013 on an IEC visa, also known as a working holiday visa was the terms we used at the time. When I came here first, I did 1 season up in Whistler before joining the real world, coming back to Vancouver. I came through the PR system in the first year of Express Entry, and I came through on Canadian experience class. So I have firsthand experience coming through the immigration system and Express Entry. Don't have firsthand experience of everything that came before that. After that, I was called to the bar in British Columbia in 2017. I then obtained my Canadian citizenship August of 2019. And then since the last couple of years, I've been practicing predominantly in immigration negligence. So that is taking lawsuits and cases against the bad actors in the immigration world. And we're going to get into quite a bit of detail about what that is and what it looks like throughout the presentation. But that's predominantly my practice. And so what I want to do before we dive into the really boring parts about the law is just introduce a couple of concepts to people, just so I can guide you. And as we're getting to questions and answers, these will become really important. And the first and my most favorite one is compliance versus customer service. So often, when people come to a problem to me with a problem, the question I have is this a compliance issue or is this a customer service issue? And customer service issues, we'll get into in a second, generally not going to be the basis of a lawsuit. Compliance issues are a different thing. So compliance will focus sometimes on internal processes and policies and procedures. That's to make sure that the company is doing what they need to do, that they're legally required to do. the company can take care of things like that when they create compliance checklists, conduct audits, and generally check the processes for the people that are working for them to see that they're doing everything correct. And so if you're somebody who is joining the call today and runs your own business, compliance and compliance audits are going to be the best way to find out you don't get sued. So compliance also requires you to check what laws you are operating under and what ones you need to comply with. So when someone falls out of compliance, either with the laws or with their regulatory processes, that's when legal issues may come along. But customer service is a different issue. So customer service, that focuses on external interactions with customers, and includes things like resolving issues and providing support, not always resolving the issues that the client has hired you for, and not always providing support for those. So we live in a world where anybody can pick up Google and write a negative review about somebody for a customer service issue. Maybe they felt an employee was rude, maybe they felt they weren't listened to, maybe they were unhappy with an outcome. And all of that can be a customer service issue. Anybody who comes to us with a customer service issue, very, very unlikely we're going to successfully litigate against somebody with a customer service issue. Just because you have to actually break laws, and we'll get into the negligence framework soon, but that's often the problem. We deal with compliance versus customer service is a framework we look at. And I always like to include this when I'm talking about compliance versus customer service. The number one complaint that the Law Society of BC receives pretty much year on year is a failure to communicate by the lawyer to the client. So that is a good example of something that straddles both a compliance and a customer service issue, because your lawyer failing to communicate to you might be a customer service issue, depending on the types of communication that's needed. So failing to keep you up to date on things may be a customer service issue. If a lawyer fails to communicate something important, like a deadline, or fails to give you an offer, then, I'm sorry folks, there is a very loud train just goes by once a day, maybe sometimes twice a day, past our office, and it is this loud every single day. So I'm glad you all got to experience that with me today. But as I was saying, customer service versus compliance, the issue about communication. If you fail to communicate an important deadline or important thing, that can be a compliance problem as well as a customer service problem, and might form the basis for a lawsuit. So that's an important thing to remember as well. Sometimes there is issues that straddle both of them. The other thing I wanted to explain is the difference between regulators and lawsuits, and how those play out, especially in terms of immigration. So regulators are supposed to take action to regulate professions. They're meant to stop systemic issues and prevent people practicing in a problematic fashion. So the Law Society of British Columbia, they regulate lawyers in the province of British Columbia, like me. And the idea is that if I was practicing in a way that is troublesome or problematic, they will act on those complaints and take regulatory action against me. So one of the things that anyone who follows me on LinkedIn will note that I often complain about the CICC, or I'll call them the college, as I often do, because they completely, in my view, fail to regulate the profession that are acting in a problematic fashion. They are completely failing to take action against the bad actors in that field. And that's the difference that I see between the college and the Law Society. The Law Society is taking action against bad actors in the Law Society, and they take regular action, about 150 or so decisions a year. The college, even when they know about the bad actors, don't take any steps. We're looking at about 7 to 11 regulatory decisions per year from them. And I'll have a slide right at the end about all of that. But what regulators do, to explain, is that they take actions against the individual in their regulatory capacity. So they don't offer solutions to people who want to sue for damages or to get refunds. Their job is to make sure to give professional sanctions to professionals that deserve it. Lawsuits, however, on the other side of it, are designed to compensate people. So they're designed to provide solutions to a one-off situation. So this isn't an ongoing course of action a person will get sued for. It's a one-off. So think of it like a rear end collision, right? You're being sued for the actions you took in that moment, not your, lifetime of driving. So they're not going to look at the last 100 hours of what you did. They're going to look at what happened in that one specific moment. And that's why it's very important that I have on here that the defense of I usually don't do this isn't available. If you miss a deadline for a client's file, you can't say, well, I hit the deadline on my 100 other files I did in the last 5 years, but this one I missed it and I'm sorry. That might be an answer to a regulator, but that will not be an answer to a lawsuit. And we're going to go through a couple of stuff we can do at the end on what can be done to combat immigration negligence and immigration fraud in the vacuum of the regulators acting. So a part of how we tackle that is these lawsuits that we're taking, where we're hoping to hit them in their pockets in order to generate some change, in order for them to see that there's a financial cost towards failing to regulate. And we'll go through some slides at the end in terms of what I think we can do. But since I mentioned lawsuits a number of times, I thought I should explain to you all what it is you can be sued for, or what kind of lawsuits are open to people to take. And so there's a lot is the answer. So I've given just a small smattering of them here. The one we're going to concentrate on today is negligence. That's the focus of my practice, immigration negligence. And that has a very simple and straightforward framework that we can look at. But there's lots of other things, and it does depend on the specifics from the situation. So what happened to that individual and what's the best course of action? Now, what we see often with these immigration files is that they are interconnected. There's a lot going on in someone's life that's connected to their immigration status, things like their healthcare, their employment, and various other things that flow from that. So what you can be sued for and the effects are huge. Some of the examples we have might be a breach of contract. So if you've hired an immigration practitioner, if that's a consultant, a lawyer, or even maybe a settlement worker, you typically will have a contract with that person. And one of the first things we may look at is whether or not the person has lived up to their side of the contract. Have they fulfilled what they were contracted to do, or have they failed? Another part we can look at is human rights tribunal. So there's a human rights tribunal in BC. Claims can be filed there for human rights violations. We have employment law. So if somebody's employer is mistreating them, there's cases can be taken in employment law. There's things like the employment standards branch. That's going to be a big thing for when people are mistreated in terms of employees and if they're not paid the correct amount of money. We have a very good, very large employment law department here at KSW who deals with lots of cases like these. And we have a webinar in, I think it's about 2 weeks, with my colleague Jensen. He's going to talk on his webinar about termination and the types of cases you can do with that. Lots of really good information in that one for employment law and unfair dismissals. So that isn't the focus of my practice, but I just wanted to highlight those as potential lawsuits. You can also take cases for a breach of confidentiality. So for example, if you are feeding confidential client information into a open source AI program on the internet in order to do your work for you, there's a good chance you might get sued for a breach of confidentiality and the regulator take actions against you. And I have seen services being offered where they are basically just putting the information into ChatGPT to fill out immigration forms. And I can only see that going badly for the practitioners who are involved in that service. You can also sue for a breach of fiduciary duty. So that's when someone has failed to act in a client's best interests and put their own interests ahead of the client's. So when they've decided to make money instead of the client, that can be a real problematic issue. There was a decision from the college this year where one of the consultants had contracted with a client, and she then had that client of hers set up a business with her husband, and the college felt that that was a breach of that duty. So what we're going to look at in a little more detail for the next 10 or 15 minutes is negligence law. So this is the focus of my practice, and it comes with a 3-part test. And anybody who is a lawyer attending the webinar or went and did a law degree will probably recognize the case down at the bottom, Donahue versus Stevenson from the House of Lords, 1932. And that is where negligence was born. That was where there was a snail in a ginger beer. And it was one of the first cases we all learned in law school, and one of the ones everyone remembers, because it is not every day you get a snail in a ginger beer. So the case from the House of Lords set up this 3-part test, and the test is still good. It's still good law, and it is still what the courts look at today in order to assess these cases. In order to succeed in a case in negligence, you have to run the board on it. So you have to establish a duty of care, you have to establish someone fell below the standard of care, and you have to establish that that directly led to damages. So those become a little more detailed in each version of the test. But the important thing to remember is that you have to run the board on all 3 of them if you want to succeed in a case of negligence. So a duty of care, this can be challenging in a lot of negligence cases, but in the immigration world, this one is actually relatively easy to prove. So a duty of care is all about the relationship you have between you and the person. So what you're trying to do is establish whether a relationship existed or not. That's the challenge in cases that are not to do with immigration, whether these 2 people had a relationship that created a duty of care. If you signed a retainer with an immigration practitioner, a lawyer or a consultant or anyone else who offered those services, you pretty much have established you have a duty of care to that person. So one of the first documents we'll always ask people for is the retainer to see whether a duty of care exists, and then we're going to be looking into that retainer to see what is everybody contracted for, right? Part of this duty of care, we have to establish that the client had paid the lawyer or the consultant money for the services. So that's the quid pro quo you need there. Services provided, money exchanged. We have to be careful as we're looking at these immigration cases to see that we're not falling into a crack where a relationship doesn't exist. So, for example, if somebody has read, your blog on the 5 best ways to get PR, and they, went and filled out their own applications and sent those applications in, and they got rejected, very unlikely that that would establish a duty of care because they've just read that blog on your website. So, you were a bit at arm's length. There wasn't that relationship created. But if someone's retained you in order to do that, then you're likely looking at a duty of care. Another situation where practitioners should be a little bit cautious is if, for example, you're on like a community Facebook group or a WhatsApp group and you're giving advice in your capacity as an immigration consultant, you just need to make sure, that you're not establishing a duty of care or a relationship between the 2. You're just giving your opinion on things. Because the last thing you want to do is be sued for some information you provided in a group chat to others. So that's the first part of the test, and it is generally speaking a relatively easy one if there's a contract. If there's no contract, you might have other questions that come up for a duty of care. But where the bulk of the analysis is, where the real meat in these cases are, where they live or die, is the standard of care. So the standard of care is, has somebody done something in this profession that is below what the standard of care for that profession is? So it's, something that somebody of relatively acceptable skills or experience just wouldn't have done. So the courts won't be looking at a judgment call that went bad. If that was an okay judgment to make and the outcome didn't work out, that won't fall below the standard of care. What they're looking for is the information the people had at the time. So they're not looking with the benefit of hindsight. They are looking for, what did you know at that time and what did you do? And so in order for you to succeed in a case of negligence, you have to establish that they've breached this duty of care by falling below it. So typically in a trial in negligence, you will have a standard of care expert, and that's somebody to give opinions on what that standard of care is in the situation and why this person fell below it. So we recently did a conference at the CBA in Victoria, the national conference, and we went through 2 fact patterns there to see whether there was a breach of the standard of care or not, from my point of view. And then we had lawyer who was doing federal court cases on incompetence of counsel. And the incompetence of counsel analysis and the standard of care are similar, but they're not the same. And that's really what's important to remember here. So if you're an immigration practitioner on this webinar today, just remember that if you're doing an incompetence of counsel application, it's not the same test and the standard of care isn't the same. It can be really challenging to align those two. But if you have an incompetence of counsel finding from the federal court, that's going to be excellent evidence in a standard of care case. And so standard of care applies in all negligence claims, but it's more particular when it comes to professionals. And because a standard of care may exist between two lay people, but if you have a lay person and a professional, then the standard of care is going to be to that professional's level. So a higher standard of care is applied to people who represent themselves as having a special skill or knowledge that allow them to perform tasks that are normally beyond the capacity of an ordinary person. So this is some case law language, and it's what judges look at. But the point that's important to take from this is that anybody who is presenting themselves as an immigration lawyer or an immigration consultant are presenting themselves as someone who has special skill and knowledge, and they're able to perform these tasks on behalf of people. So you're going to be held to a high standard of care if you're presenting yourself as an expert in that. And with that comes scrutiny in terms of all your actions. So we have a case, and there's not many cases on the standard of care on immigration lawyers or immigration practitioners in the civil courts. There's only about 3 or 4 nationally that talk about it. But Romans versus Howland is the leading case because it's the only one that actually was a case in negligence against an immigration practitioner. And we'll go into the next slide is going to have a little more detail, but very simply, the consultant failed to advise the plaintiffs about the availability of a flagpole application, and that the court held was below the standard of care required for the immigration consultant in that specific circumstance. And it's actually a fascinating case to read for all people who find cases fascinating to read. It's a 2010 case, and it's a bit amazing that nobody has taken a case in negligence to trial against an immigration lawyer or immigration consultant in any of the provinces in Canada since that time. So we had a case in BC recently where there was a failure to certify a class action against an immigration consultant. And that gave us some excellent court opinions on what standards were required for an immigration consultant in terms of fiduciary duty and recruitment practices and things like that. But it wasn't the case in negligence. So it gave some good information to us. We also had a case in BC, I think it was 2023, Zong was the name of the case, where a person was getting advice from what they called an immigration consultant, but it was actually it was an unauthorized practitioner. So it wasn't an immigration consultant that was regulated by the college. They were just calling themselves a consultant in regards to immigration. And the court held them to a higher standard because they were presenting themselves as somebody who was able to give advice in relation to immigration law and investments, because this person in the Zhang case wanted to invest in a business in Squamish and use that to immigrate to Canada. And as you can assume by the fact they're suing each other, things didn't quite work out as they planned on that one. So Romans versus Howland is the leading case in negligence for an immigration practitioner from the small claims court in Red Deer, Alberta. So hopefully in the next year or so, we will have taken a case to trial in BC here, and we will be able to have set a precedent that will help guide us for these future ones. But right now there is a kind of an absence of specific immigration consultant or immigration lawyer cases. So we have to go on what the court does in other ones. But the Romans versus Howland one is a fascinating case because they succeeded in 2 of the 3 parts of the test. And that is that they established a duty of care. They established that the consultant's conduct fell below the standard of care. But actually what the court found was that damages never flowed directly as a result from this conduct. They actually found that the immigrant was actually in a better position because she got her work permit 2 months earlier rather than following the consultant's advice. So It is a lengthy decision. I would strongly recommend reading it. But for a very quick overview, because I know all the immigration practitioners always love hearing about this case, what happened was there was a Japanese lady met a Canadian man as they were both doing a year in Australia, and they started a relationship and they wanted to continue that relationship. So he returned to Alberta. I think he's from Red Deer originally. And she went back to Japan, and then she came to Canada in order to get a working holiday. And so she did all the applications herself. She entered initially on a visitor visa. Then she did some schooling, English as a second language, which she shouldn't have done. And then she intended to get a job. So while she had her visitor status, she hired the immigration consultant in order to get the work permit for her. And there was some complications along the way. You should read the case for a little more details. But ultimately, what the consultant advised them was that their best course of action was to apply for a work permit from outside of the country. So they applied for a work permit to be processed through the Seattle office. And she was required to go to an interview in Seattle at some point and do all that. In the meantime, the couple took a trip to Seattle. I believe it was for a concert. And because her boyfriend didn't have a passport, he had to drive over the border. So they didn't drive from Red Deer, they flew to Vancouver and drove across the border. And when they finished their weekend away and were coming back into Canada, the border guard had asked a question to the lady and basically got to the bottom of, she was applying for a work permit. It was in play, but what they had done was unintentionally flagpoled. And the border guard had said, because you've left Canada and re-entered, I can actually issue you the work permit now, as opposed to waiting for the couple of months that they would have had to have done. And so what happened was she then re-entered Canada on her work permit 2 months earlier, because she had unintentionally flagpoled because they went to Seattle for this weekend. And what the court looked at, they looked at all the correspondence between the consultant and her throughout their engagement, and saw that he never recommended a flagpole application to her. And when asked about why he never recommended the flagpole application to her, his evidence was that, well, I knew her financial situation. I knew she couldn't afford it. I knew I charged $8,000 for that. And I didn't present that as an option because I thought that her and her boyfriend couldn't afford it. So took it off the table for them. So what the court said was, you don't get to make those decisions on behalf of clients. The court said that you must present all immigration options to the people and let them make the decision. So one of my colleagues who's an immigration lawyer just up the road from us here in Surrey, she always says that our role as lawyers, and this is true for immigration lawyers and consultants, is to analyze and communicate. And decisions are only made by the clients. And this case is a perfect example of that. So the court held that they fell below the standard of care for failing to give all the immigration options available to her. And the evidence of this was that she unintentionally flagpoled, got her work permit earlier, and she was able to go to work 2 months earlier in the job that she had lined up. So that's where she failed in terms of damages, because she didn't lose any money. She got working 2 months earlier, but the court held she fell below the standard of care. They fell below the standard of care for failing to give all the advice, all the options in their advice. So that's an interesting case for those reasons to explain. And it's a nice segue for me to explain damages and the kinds of damages we see in these cases. So the important thing to remember with damages is they are determined on a case-by-case basis. So it is very hard to say, well, because person A got this amount in damages, person B will get this amount. Personal injury files have always had that problem. They're a good guide as to what happened before, but they are not determinative of what will happen next. And the court really does look at the individual circumstances. So here's a couple of stuff that we will always claim in terms of damages on these files and the kind of typical things we see. Again, nothing is necessarily excluded, but what the court will use as their measurement for these cases is what's called the but-for test. So, did you suffer these damages but for the negligence of the person who caused it? So the first one that we always like to look at is special damages. So these are out-of-pocket expenses incurred because of negligence. So, for example, if you hired an immigration lawyer to do your work permit and that application got rejected, and you then had to fire that lawyer and hire a new lawyer to remedy those issues, that expense of hiring the second lawyer to fix the problems from the first lawyer would be an example of an out-of-pocket expense that you had to incur as a result of that negligence. So those would be types of costs you can try and recover. If, for example, you had to, leave the country because of the negligence of a consultant or a lawyer, you may be able to recover things like the flight fees out of the country or anything else. So it does very much matter on a case-by-case basis what fees you incurred. If, for example, you were going to incur those fees or costs in any event, then it's not something we'd be able to claim back. So we just recently spoke to a potential client who had her express entry application got rejected due to what we would consider negligence. But so she decided then that her best route was to upskill her education and learn French. So what she did was she enrolled in a university course in France in order to up her education to get more points and increase her French score so that the Francophone options could be more open to her. So in a case like that, we would be looking to make a claim for those special damages and expenses for her going to France. Another big ticket item for damages we have is past wage loss. So if somebody has had an application rejected or refused and they go out of status, we'll say they're out of status for a year before they can get back working, that year will probably equate to past wage loss. So if someone is out of work and they were earning $50,000 for that year, they may have a past wage loss claim of $50,000 for that year. Obviously it depends fact specific and it goes on a case by case basis, but that is a good example of the kind of thing we see pretty regularly and the types of wage loss claims that we put forward. Another one that we always claim and is very tough to quantify is a loss of opportunity. So this is just really, really case specific. What are the kind of opportunities that you have missed out on by, we'll say, being out of status for a year? The same way that we just explained about the past wage loss. So, for example, there can be a case where if you were out of work for that year, were you in line for any promotions or pay rises during that year? If you were somebody who was part of a union, have you lost seniority in the union? Are you now back down to the bottom? If you were out of status for a year, one of the things we see regularly enough is that someone would also have a lack of access to healthcare for that year, and that can have a direct impact on family planning and things like that. So if you were planning to have a baby within the next year, I would say after you got your work permit, after you got your PR, and suddenly you now have no status, you've no healthcare, you're putting on hold those plans to have a baby. So those are some of the examples of damages that we can see in these negligence cases. And here's some common examples of the things we see that may or may not lead to a negligence case. So failing to advise on all the options, that's straight from the Romans versus Howland case. Failing to advise clients in a timely manner. If somebody it gets a request for more information from the IRCC and you've only 30 days to submit that information, then you need to communicate that to the client on day 1, not on day 31. You got to provide clients with accurate and complete information. Cannot provide them with incorrect advice or information. That's just going to go down to the quality of your advice. Another thing we see is fees. So if someone's charging fees they shouldn't, that would be another example of something we could take a lawsuit for. Failing to upload the correct documents when filing on behalf of a client. We've had cases where someone has uploaded other clients' information on these applications and had them rejected. Failing to disclose conflicts of interest. So if you have a financial interest in something that you are doing on behalf of a client, you need to disclose that. Otherwise, it might lead to a conflict of interest, which you could be sued for. Failing to act in a client's best interest. So if we can establish to the court that you haven't acted on a client's best interest, that's going to be very hard to prove that that isn't below the standard of care. If you fail to maintain client confidentiality, that will also be problematic, could also lead to a lawsuit. And one that I see quite often, and if you leave today with no other advice as an immigration practitioner, is failing to advise of an appeal period. So any negative decision will have an appeal period, and you need to tell your clients what that appeal period is. Other considerations for lawsuits. You have a 2-year limitation from the day you discover the negligence to file your case. So don't wait until one day before the 2 years, because the limitation is an ultimate defense to a case. It can be, your whole case can fail if you file it too late. So don't do that. Speak to us as soon as possible after you've discovered any potential negligence, and we can give you the advice on what to do moving forward. Sometimes you might need to file your claim in order to maintain it, which we do often as well. One thing we do see regularly in the defense to these cases is refunds. So someone will say that I've fully refunded the person, so therefore I'm off the hook, right? It's just something to be aware of. If you're accepting refunds from a person, make sure you don't sign away your liability, don't sign a waiver, don't sign a release. Make sure that you have in writing that this is just a refund. It doesn't have any effect on any other legal complications for you. You do not want to release all your claims by getting a refund. One other consideration we see in these cases is government discretion. So it's going to be very hard for us to take a case in negligence or sue somebody where an immigration application is purely on discretion. So we're looking at refugee cases or H&C applications for that. Those are applications where you submit all the information to the government and they make a decision based on the person and the information. So it's going to be very hard for us to prove in, we'll say, a H&C application that had these other 2 or 3 bits of information been given, that a different outcome would have happened. That's just going to be very, very tough to prove, and we would, generally speaking, not take cases on that. You've got the defense for misrepresentations and their effect. So always be aware of what misrepresentations constitute in the immigration world and the effects they can have. These are going to be troublesome, and what we often see in terms of a defense is that any misrepresentation that the consultant or the lawyer made was because they got that instructions from the client. So always make sure you're telling your practitioners the truth. There's also some regulatory complaints process. That's a factor you should consider in terms of what you want to do in the lawsuits. I will get to that one in another slide in just a little more detail. But I want to explain to you what could go wrong and why you should not make sure you do not hire an unauthorized representative. So this is a document that was doing the rounds on LinkedIn in the last couple of months. And what you're seeing is the IRCC are trying to clamp down a lot on these unauthorized representatives, and it is resulting in refusals and rejections. So what we are looking at here was this client's application was approved, and then subsequently that approval was pulled because they found that they had used the services of an unauthorized representative. Some of the ways the IRCC are checking these things is that they did a sweep of credit cards. So there was a lot of applications paid for by a credit card that was not related to the individuals who made those applications. And they knew that they meant they were using the one individual to pay for all these, and that individual was not a qualified consultant or a lawyer, so they knew they were an unauthorized representative. If you use an unauthorized representative, you may end up with something as severe as a 5-year ban from Canada, and you can get refusals and rejections like this. And one of the big problems you will have, 2 big problems, if you come to me and you want to take a case against a unauthorized practitioner, is that we have no regulator to complain to. So you're going to be just going after the individual, and you'll have no real chance of being able to sue them, again, because they have no regulator. So those are 2 big problems with using unauthorized practitioners. And even using authorized practitioners, you also can end up in problems. So this is an example of a story where we have a case that we're dealing with, where we have a client. She moved from the Philippines to Canada. She was working in Alberta, but she was offered a job in Saskatchewan. A immigration consultant in Saskatchewan was recruiting her for this job. So she moved her family there, and the job she was offered was as a restaurant manager, but when she landed, it was actually going to be a line cook she was doing. So they had a skilled work on paper to make it to qualify for immigration programs that she was not necessarily qualified for. Now, the other issue she ran into was when she moved there, she had a valid work permit. Her consultant never filed an extension or any other application before the expiry of her work permit. And the week after her work permit expired, he told her she had the legal authority to work because she had implied status. And she didn't. But that was the information and advice she was given by her consultant. So she was working on incorrect advice. She then, after that, discovered she was out of healthcare or out of status when she applied for Saskatchewan Health. Then she got advice, found out she was out of status and working without legal authority. So she stopped working. She lost her ability to apply for EI. Her children were left in limbo because they couldn't go into the schools because she had no status, although they did ultimately end up going in there. But then the real problem for her was that she had no access to the healthcare. And during this time, she was out of status for maybe a year and a half. About 6 months into being out of status, she started to detect lumps in her breasts, and those lumps were getting bigger and bigger as time went on. Those lumps got bigger in size for about 3 or 4 months until she ended up paying out of pocket to get a mammogram for herself. And that's when it got confirmed she had stage 3 cancer. And so she now owes hundreds of thousands of dollars to the Saskatchewan healthcare system, who had to treat her, but have now sent her bills for that. And all of this came from incorrect advice about her working while unemployed status. So one of the things we want to warn people about is that things can go wrong whether you're using authorized or unauthorized practitioners. So as any lawyer will tell you, prevention is better than a cure, right? Not getting into these situations is always going to be better than getting into them and coming to us to fix it, because any fix we can offer is lengthy and time consuming and really delays any outcomes when if clients can't get that solution right away. So some of the things, to give you guys some tips on how to spot the bad actors or how to spot people who are doing fraud and negligence. We at KSW Lawyers, we post on our social media tips on how to do that. It's usually about 1 tip a month on what to look for. And these are just general tips on immigration practitioners. So you'll see at the bottom, the one that I always tell people to do no matter what professional you hire, verify their credentials. So have a look to see if a person is registered with the college or registered as a lawyer with the local law society. You know, we deal with people all the time who come to a consultation with me and they say, well, the lawyer I hired was this person. And once you do a search for them online, you find actually they're not a lawyer, they're not a consultant, they were just saying that. So make sure you verify that information before you go and speak to those people and hire them. Do your research. There's lots of tips online, lots of really good tips. The problem is that people have those tips, they just don't always execute on them. So they're not always looking to it. And if you're looking for one guiding light, one rule of thumb in order to spot a person who is a bad actor, if they're promising you something that's too good to be true, it probably is. So always have a little skepticism if something you're being promised is just too good to be true. But the main thing is tune into the social medias to get our monthly tips, and hopefully you can pass those on to your clients, or if you are a person who's looking to hire an immigration practitioner, hopefully you can take those tips on yourself. We do also have an immigration lawyer on staff here at KSW. So anyone who is looking for any immigration work to be done, we can offer a lawyer to help with that service as well. So if you do encounter a practitioner who is a bad actor, the best thing to do is to report your concerns to the regulator. So that is the college, to the extent to what they'll do with it, I don't know, or the local law society. And I always tell my clients, or anyone who asks me, never be afraid to report anything that's accurate. As long as you're telling the truth to the regulator or about the person's conduct, it's not something I would necessarily have too much of a worry about. If you are considering suing the person, it might be worth contacting a civil litigator to make sure that no statements you make will cost anything in the lawsuit. So as long as you're telling the truth, it's generally fine. You just want to be sure. So contact a lawyer to look over that statement if you're considering litigating at a later point. It might also be worth contacting an immigration lawyer to see nothing that you're putting in that statement will be prejudicial to your immigration applications in the future. If you're writing a complaint, and this is generally true for any kind of legal writing, avoid emotive language and just stick to the facts. So don't write in your complaint, I was ripped off and scammed out of $20,000. Instead say, on January 25th, 2025, I paid my consultant $20,000, which is, sticking to the facts. Let them make the determination if you were scammed out of it. And what I would recommend to people is don't be afraid to report out of fear of retribution. That fear exists, and generally speaking, IRCC will understand. The college will not take any steps against your immigration application. Law Society certainly won't. But those entities, the Law Societies, the college, IRCC, they depend on complaints to take steps. They're not proactively out there doing it. And the point I always like to hammer home to people at the end of this, and why this is so important, is according to the college's official statistics, since their inception in 2020, so the end of 2020, so we're almost coming up on 4 years to it now, 5 years to it now, they have only received 682 reports about unauthorized practitioners. So, and I just want to really hammer that point home, right? 682 reports total in their life to the college. I can assure you, if I was to just spend the afternoon looking for unauthorized practitioners today, I could find 682 of them myself to send to the college. But the fact is that they are just not getting the complaints. And so these bad actors are flourishing because there is no complaints and enforcements. So really, really want to make that point. Unauthorized practitioners need to be reported to the college. I've made a number of reports this year. They've gone nowhere. But I'm trying not to be discouraged about their slow responses and their ineffectiveness. Because if we don't do anything to tackle these problems and the bad actors, they're just going to keep on going. And the last slide before we jump into questions here is just a quick look at the disciplinary numbers from the college. So this is from their annual report. They post these statistics every year. And it's something that I think a lot of people are unaware of. So the numbers on the left are the amount of consultants we have in Canada and outside of Canada. So you can see it's 11,999 within Canada. That just leaves 265 outside of Canada. So one of the things I see online all the time is people are saying that, a lot of the bad actors are outside of Canada. Not what I see in these stats, and not what I see online either. I see bad actors across in the country, out of the country. But where I really want to focus your attention on is the numbers on the right-hand side. So as of in July 2023, there was 1,800 open cases in the college. In the year that this has been reported, they had 1,018 new cases. So that's July of 2023 to June of 2024. There was 1,000 complaints to the college. So it's practically 3 a day. And if you look just further on, they tell you how they filtered them. They closed some, nearly 452 at intake, 460 or 480 at early resolution, 280 investigations, 46 got referred to the complaints committee, and 64 to the disciplinary committee. And I would say those numbers are very inadequate. And what they had at the disciplinary committee, so these are the only disciplinary decisions, there was 5 suspensions, 6 revocations. And that was in the year July 2023 to June of 2024. So July 1st to June 2025 will be in the next annual report, which will come out, I believe, in November of this year. And you'll see, again, a failure to actually take steps against the bad actors doing this. So the college, like I said, depends on these complaints, but they are using the numbers for a lack of complaints to say that they're doing a good job. And right down at the bottom here, hidden in the stats that they don't like to tell you about, 61.4% of the 1,544 open cases are attributable to 127 licensees. So the college has a clearly identified group of bad actors that they are just not taking actions against. And this is a problem that I recommend anybody take up with your local MP, write to members of the federal government, because the IRCC has supervision over the college, and the failure to take these steps are really what allowing these bad actors to flourish and do better. So really, really, really want everyone to leave today thinking that they can make a change if they make these complaints and issues and push them to take steps against these identified bad actors that the college is slow walking the decisions on. So if they do 11 decisions a year, like they did in this reporting year, it's going to take us over 10 years to get through those 127 bad actors. And that, as my final point, is just simply not good enough. And so with that, I think Taryn is going to have hopefully some questions from the chat, or anyone who has a burning question they've been waiting to type. Now is probably the right time to do it.
All right, so the first question we have here is asking whether a client can claim damages for not getting selected for permanent residence due to an action caused by the lawyer, which led to a delay in his work permit.
The very simple answer is yes. It depends on what they did wrong to cause that mistake or that delay. So that's going to be a standard of care question. If they made a mistake that, for example, if they failed to put in someone's relevant education, and that education would have gotten them enough points to be pulled at the draws that happened at that time, and then they subsequently updated the profile and added that education later and got pulled later, you can probably claim damages for that delay, yes.
We actually also have two questions asking about red flags for bad actors and how to detect them in general.
Mm-hmm. Oh, I feel like I could talk for an hour on this as well. So bad actors will have lots of smooth sales stuff. So they're going to try and give you like a limited time offer. That's one of the big things we see with people. So they'll say, well, you know, we have these employers lined up who can offer you this job, but you have to sign up today. You got to sign up this week. One of the other things we see with the bad actors is that the fees that someone gets quoted initially, that number will change and start increasing. So what, you know, someone may sign up and say, oh, you're going to pay $7,000 to do a work permit. And as time goes on, then the next thing they'll say is, oh yeah, now we have some additional fees. We need another $1,000 here. We need another $500 here. Those are always good indications of bad actors that are trying to take advantage of people if the price is always changing. Bad actors will also have often no retainers or badly drafted retainers. So if someone has a badly drafted retainer or is offering a guaranteed job or guaranteed outcomes, those are kind of red flags as well to see. So all of it kind of comes back to, if it is too good to be true, it probably is. So if the bad actors, what they want to achieve is to get the money out of the person's pocket quickly and then not have to deal with the person again. So if you're looking at a situation where someone is asking for a lot of money quick or a lot of money up front, that might be time to take pause to see. Legitimate professionals and good actors, I guess, won't mind you asking questions about the retainer or the scope of services, and they'll probably be more happy to explain it. If the bad actors will be a lot more dismissive of that kind of thing. So we do deal with these in our monthly tips, and there's a few of them that have gone up already. So I would recommend looking at those, but it can be very hard to spot these bad actors because they are flourishing with the failure to regulate. A lot of them are pretending to be consultants because the CICC won't clamp down on that. So just be very suspicious at everything promised.
All right, our next question is a little bit on the longer side, so bear with me while I read it. What's your take on non-RCICs gaining control of immigration consulting firms? They hire RCICs as employees. CICC does not regulate the firms, but only the individual RCICs. I do not know of any other regulated profession where a non-professional can become a director in the professional corporation.
This is an excellent question, and a complete failure by the regulator, in my opinion. So what my take on it is that it should not be allowed. So just recently, I was interviewed by by CBC about a immigration consultant, Mr. Barwal, whose office operates just about 2 blocks over from us here, just the other side of that really loud train you heard earlier. It actually is closer to his office than my one. And this was one of the big issues that I brought up to the CBC. And I said, you can have non-RCICs owning these companies, but they're not subject to ethical regulations or requirements to follow the rules. So they can hire individuals underneath them, but they're not subject to it. And you're right, it is a unique thing in that profession. And it's something that opens the door for bad actors. And it's something that if I was to make, if you gave me a magic legislative wand tomorrow, that's one of the first things I would change. That only RCICs who are in good standing can own these firms and only disperse the profits to themselves. So you can't have individual stakeholders who are taking advantage of people to do that. That's what we have for laws, in the Law Society. Non-lawyers can't own law firms and they can't hire lawyers to kind of do the bad stuff. So my take is that it is a failure in regulation, which is allowing bad actors to flourish. And again, a failure by the CICC, the college, to regulate that.
So this next one isn't a question, just more of a comment. This individual says they've reported so many of these bad actors, but the college doesn't do anything and they never get back to you.
Yeah, I entirely share that frustration. And that has been my experience too. The college has, generally speaking, never got back to me, with maybe 1 or 2 exceptions where they have got back to us and the result has been completely inadequate. But the point I was making with the UAP slide is that the college is pointing to the lack of numbers, making these reports to say that they're a success. So 682 unauthorized practitioners, and they're pointing to that number saying, see, we're only getting 682 complaints over 5 years. This isn't a big problem. And they're kind of massaging the stats in terms of their disciplinary decisions. So much stuff are getting closed at early stages. So make the complaints. I know that they're not going to go anywhere, but the numbers need to be in there. And you can also make your point to your local MP and to other people involved, because ultimately this is going to come to a head at some point and that we need to have the stats to back it up. But I completely share those frustrations.
We have someone in the chat wondering where the membership money is going if the college doesn't do anything in these instances.
So my other favorite page from the annual report, apart from the disciplinary decision page, is the budget page. And they report their budget and what they spend their money on every year. So I would look to that. They have a operating budget of around 23 million for the last couple of years. And typically they spend all 23 million every year. So the largest portion, I believe, goes to salaries. It's around 10 or 11 million. So generally speaking, your money is going towards the salaries for the people who work at the college. So read the budget page. Where the money goes is accounted for there. Whether it's being adequately assigned to the correct priorities is probably a different question.
So someone in the chat is asking if CICC's lack of response to unauthorized practitioners is due to the fact that they don't have authorization to deal with them, and if CICC can only attend to individuals who are licensed. And they're also wondering if that's the case, how can we change it?
Excellent. Another excellent question. I always like it when these excellent questions come through, because it means that people actually understood what we were talking about and asked appropriate questions. So the CIC, I post about this on LinkedIn often. Section 77 and Section 78 of the College Act permits the college to take action against anybody who is not a licensee under the Act. So anyone who's presenting themselves as a consultant or who might be misconstrued as a consultant, the college has the ability to take actions against them, including taking out injunctions for them to stop doing the actions they're doing. So the college certainly has the opinion and belief that they are not authorized to take actions against anybody who isn't under their umbrella. The legislation says something different, and what you have is sort of a lack of a desire to do it. So the Law Society has a very similar provision. If someone pretends to be a lawyer, that the Law Society can take injunctions out and prevent those people from presenting themselves as a lawyer, because the Law Society's mandate is to regulate lawyers and protect the public. So you'll often see the Law Society is putting themselves forward as a regulator in the public interest. So Section 3 of the College Act has that same wording, but the college has decided to interpret it different from every other regulator that exists in the country. And what they have decided to do is that they say they view their mandate as regulating licensees in the public interest, as in that's one thing, not two separate actions. So it's not regulating licensees in the public and acting in the public interest. They see it as regulating licensees in the public interest. So the college has the power to do it. They could show up tomorrow and take action against these UAPs by filing injunctions. And I should point out, the legislation limits that action only to them. So only they can do it under their own legislation. But they've never done it, not once. And I don't see a way to change it without changing the management or the board at the college.
So it is 1 o'clock, but we'll try to run through our last questions as fast as we can. Our next question is wondering if there are any new rules to regulate immigration consultants, and if it's too early to assess the impact of these rules.
Well, the new rules came in, and the Code of Conduct came in place on June 11th, 2022, and there was new rules in place from the college when it got incepted. So, and that was nearly 5 years ago. So in my view, it is not too early to assess it. It's very easy to assess it. In my view, it's failed. And the regulator is failing the profession, and it's failing the public. They're failing to execute their mandate under Section 3. So the new rules are actually pretty good. I would suggest that the college has excellent regulations on paper, and the legislation under Section 77 and 78 gives the college powers that they can do things, but they're not doing it. And in the 5 years that the college has had those new rules, their membership has almost doubled. So the rules are good, management of the college is bad, and I don't think it's too early to assess the impact of those rules at all.
Our next question asks, what do you think of the movement by certain lawyers to bring licensed consultants under lawyers, similar to a paralegal role?
An interesting question, almost a political question, I would say. So let me reframe a little bit how I'm going to answer this. So the college is the third iteration of the regulator. Before 2001, consultants were not regulated. Then the Mangat versus Law Society of BC case came down from the Supreme Court of Canada. That prompted a regulator to be established for the consultants. The first iteration of it failed. They set up a second iteration after that, CSIC, I believe it was called, and that one failed. So what they did was they've had their third iteration as the college, the CICC. And right now, the movement by these lawyers is to basically to disband the college and say that if this is an unregulatable industry, that it should be brought under supervision of lawyers, same as a paralegal. How I feel about it is that I think the college's actions and failure to act is good fodder for that argument. I think that argument, having a bad regulator is a good reason to disband it and get rid of it completely. I think the poor management by the college is promoting people to make those arguments. And if I make this, I make this point every time I say it, every time I speak on the issue, that the college was legislated into existence and can be legislated out of existence tomorrow. And if the general public has lost faith in it, if lawyers have lost faith in it, and there's a lobby to get rid of it and take all the consultants in as paralegals, their failure to uphold their mandate will work towards that. So I don't necessarily think the movement is a good thing or a bad thing. I think there's lots of really good consultants out there that it would be unfair to, but I can see why it's happening.
All right, we have a bit of a longer question. So it's about liability in case of a service provided by a settlement service frontline worker. In case there is an issue with a PR application, there has been a debate regarding interpretation of Article 91 of the Immigration Act. Can you please discuss the implications in case a non-licensed individual is assisting a client fill out an application?
Yeah, another excellent question. Nothing more fun than diving into the details of IRPA, right? Federal legislation and its interpretations. But what Article 91 does is it allows settlement workers to provide this advice, similar to consultants and lawyers. And what you'll end up with is it will move to a standard of care analysis. So what is the standard of care for a settlement worker? A settlement worker of that experience and with that qualifications. And a lot of these settlement workers have very good qualifications, right? So you're going to be held to a level that relates to those qualifications. The problem is that if someone makes a mistake on a PR application or a work permit application, the analysis is going to be that standard of care. So the settlement service probably will have signed some version of a retainer with this person. So they're going to establish a duty of care. Then it becomes a standard of care whether they made a mistake. And then it's a question of whether that mistake led to damages. So I think that's probably not exactly the question you're asking. I think the question is more about how accurate do settlement officers have to, or settlement service providers have to be. And I would say that you should be doing your best to be as accurate as possible. And you could very much end up in a negligence case if they're giving incorrect advice or falling in under any of those common examples we gave earlier.
All right, this is our second to last question. They're asking whether potential immigrants are educated about bad actors in their home country.
Yeah, this is going to be a change in tone for me. This is maybe one of the only things that the college does a relatively okay job on, is they do run education programs, and they send those education programs out into various different languages, and they do try and provide education to people in their home countries. The IRCC also has education that they try and send out in different languages to their people in their home countries. And there is an effort to stop the miseducation and try to get to people in their home countries, because often that's where people are hiring consultants and lawyers from, is their home countries. The challenge is that the term consultant can be very vague. And just like the Jean case we talked about earlier, that person was using their term as an immigration consultant, not meaning an immigration consultant as a licensee under the Act. So potential immigrants are educated. There is information online. The problem is there is just a tsunami of information, good and bad, that these people are trying to sift through. And they are often going to places that are not reputable sources of information. So the education is there, but the best rule of thumb that I would give to people is the old Ronald Reagan quote where it says, trust but verify. So trust the information you get, but verify it.
Great, and this is our final question. And they're wondering, how can we move CICC to change its board members? It's something we have asked at the AGM, and they responded that they were appointed by the government. It seems we are stuck with practically the same board as ICCRC with the same results. Is there really nothing that paying members can push for?
Oh, another excellent question, and perfectly timed, because you're correct. The federal government appointed the members of the CICC board, the college board, and they appointed them on an interim basis when it was established. Now they extended that interim basis in 2023, and it was going to run, I believe, until 2026. However, just last month, they announced that they will be opening up nominations for the board. So you can actually now nominate people or nominate yourself. I would, whoever has asked this question, if you're a good consultant, one of the good actors, they need people in there to do that. So they have a small limited number of places on the board that are taking nominations for it soon, and they will be elected by consultants themselves. So look into that. I don't have the link close at hand, but it is, I think nominations are still open for another week or so. And so that's how to push for the change, and make sure that when the elections are coming up, that you vet who you're going to not elect, and try. I would strongly recommend to get rid of everybody who's on there right now, because to me, I don't see that they're doing a good job. But it's good timing, because that announcement came out of the blue at the end of July. So there's a nominating process open, and a voting process after that. So that's how to do it. And what you can do after that is hold those people accountable to follow through on the promises they made to get them elected. Oh, someone just posted in the chat, nominations closed July 25th. So yeah, just vote for the good ones then.
Great. Thank you everyone so much for joining us today. Hope you found this session informative. You can expect to get an email with a recording of the session and the slides in the coming week or two. Again, thank you so much for joining us today, and we hope to see you at our future webinars.